Welcome kapatid to our series on how to answer law school and bar problems. Today we are taking a look at a problem from the 2022 bar exam. I'll be showing you precisely how to answer a problem, how to be responsive to a problem, and how you can also arrive at an elegant and precise answer all on your own. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Without further ado, let us now begin with a problem from the 2022 bar examination. I'll be showing it on your screen right now. The first step in answering every problem is to take a deep breath. Find a way to calm yourself down. Don't look at the problem, don't look at your screen. Ipikit mo ang iyong mga mata kapatid at huminga ka lang muna ng malalim. The second step is to take another deep breath. As you exhale, know and understand that however way you're going to answer this next problem really is not going to matter. Tuldok lang ito kapatid. It is a dot, a speck, minutiae in the great grand story of your law school journey. And as you exhale, envision yourself passing your exam, passing the bar exam, taking the oath and what you'll be wearing on your roll signing. Now, you are ready to look at the problem. The third step is to read the last sentence, then the second to the last sentence, and then the two sentences together. If what you see at the end of the problem are phrases like explain briefly or discuss fully, feel free to include these with the last sentence. We do this, kapatid, in order for us to zero in on the problem. We can only be responsive if we know exactly what is being asked. We skip ahead to the last sentence because this is where the question is usually found. Remember, we can only be responsive if we know exactly what is being asked. Let's look at the last sentence of the problem. If you were the judge, would you convict or acquit Raul for the crime charged? Explain briefly. Let's read the second to the last sentence of the problem for more clues. The defense did not present any evidence. Just by looking at the last two sentences of the problem, it appears that we do not have much going on. Sometimes there are problems like these. Ang malinaw lang sa atin ngayon ay kung ano ang itinatanong ng ating examiner. The fourth step is for us to identify what is being asked in this problem. This is your guiding star. Ito at ito lang talaga ang maaari nating mabalikan kung sakaling tayo ay nalunod na sa mga facts at arguments ng ating examiner. What is being asked in this problem? Here the examiner is asking us to step into the shoes of the judge. We are being asked whether we will convict or acquit Raul for whatever crime he was being charged with. Then we must offer a short explanation. The next step is for us to identify the rule, concept, provision, or doctrine that is being asked in the problem. The master key to being hyper-responsive is by identifying the exact rule, provision, concept, or doctrine upon which the examiner has built the problem. If we can reverse engineer how the problem was drafted in the first place, then it gives us the fighting chance to give the precise answer that the examiner is looking for. Dito sa problem na ito kapatid, ano kaya ang sinusubukan sa atin ng ating examiner? What is the rule, concept, provision, or doctrine that is being tested in this problem? If what is being tested is still unclear to you based only on the last two sentences, then feel free to come back to this after the next step. Here what is being tested is still unclear. We will be going back to this step later. The next step now, kapatid, is for us to read the problem from start to finish. We will look for bits and pieces, anything really, that will help us answer the question. We will go over the problem line by line and look for clues that might help us give to the examiner the answer he or she wants. If you see an actor, mark it. If you see the actor's action, mark it. If you think something might be relevant, then mark it. All others we can safely ignore as noise. I hope I'm still making sense so far. Let's begin reading the problem from start to finish. Sometime in 2011, while police officers were conducting a foot patrol in connection with the report of rampant illegal activities in the area, Police Officer Pepe saw Raul inside a small shanty holding a disposable syringe. Being a police officer for almost 15 years and having previously made more than 10 arrests involving possession of drug paraphernalia, Pepe entered through the open door of Raul's shanty and arrested him. Inside the shanty, 23 more pieces of disposable syringes and empty ampules were seized from Raul. Pepe immediately marked the seized items, took photographs thereof, and conducted an inventory in the presence of Raul, a barangay kagawad, a representative from the Department of Justice, and a media practitioner. The seized items were turned over to the evidence custodian who kept them in a sealed container in the police station. During the trial of Raul for the crime of illegal possession of drug paraphernalia, Police Officer Pepe, the sole witness for the prosecution, testified as narrated above, after which the prosecution rested its case. The defense did not present any evidence. If you were the judge, would you convict or acquit Raul for the crime charged? Explain briefly. In the first line of the problem, the examiner tells us about Police Officer Pepe, who has spent over a decade in the service. He saw Raul holding a disposable syringe. Police Officer Pepe made an immediate arrest and found 23 more pieces of disposable syringes and empty ampules. Thereafter, the examiner narrates that Police Officer Pepe made an inventory of the seized items and he also took pictures and made an inventory. Everything so far appears to be by the book. He did all of this in the presence of the person from whom these items were taken, si Raul, and then an elected official, specifically a barangay kagawad. Also present was a representative from the Department of Justice and a member of the media. All of these things are required under Section 21 of Republic Act No. 9165 as amended by Republic Act No. 10640. In the next paragraph, the examiner tells us that Raul was charged with the crime of illegal possession of drug paraphernalia. However, it appears that only Police Officer Pepe was made to testify in court. The defense didn't bother to present evidence. In the final paragraph, the examiner reiterates his or her call. If you were the judge, would you convict or acquit Raul for the crime charged? Explain briefly. After marking our paragraph, it should look like this. After reading the problem from start to finish, it appears that what is being tested here is our understanding of the Dangerous Drugs Act, specifically the chain of custody rule. We are being tested if we understand it enough to be able to identify whether or not it was followed in a facts-based problem and whether or not it is enough to sustain a conviction. Knowing what you now know about the problem, please pause this video and type up your answers in the comment section. This is the only way for me to gauge your answers and I will try to respond as best as I can. Libre dito ang magkamali, kapatid. Hindi mo ito ikakabagsak dahil hindi mo ako professor at hindi rin kita estudyante. Huwag kang matatakot na magkakamali dito, kapatid, kung ikakatama mo naman sa iyong quiz at midterms o maging iyong bar exam. This problem is a good illustration of the technique I call leading. Leading is the process of dropping as many bits and pieces of information for a student to reach a particular conclusion or maintain a particular position or to support a given argument. Leading is all about baiting the student to give the incorrect answer. It works best against students who are prepared, who are ready, but not at 100%. Okay lang yan kapatid kung hindi ka tinatablan ng leading, lalo na kung wala ka pa sa kalahati ng iyong naaaral para sa inyong quiz o exam. Leading puts the student into a position where he or she seems to have no other choice but to agree with the position, the argument, or the conclusion that the examiner has laid down before you. On the flip side, our instincts tell us that this position is wrong, much like the story of Hansel and Gretel, when they were led to the hut or the house of the evil witch who eats little children. Leading also preys on our natural tendency to overthink our own answers. When you face questions where the examiner uses the technique of leading, my advice is for you to follow your gut instinct. If the answer is too easy, it's probably incorrect. The answer might be found in some obscure case or some exception that may not have been necessarily covered in your classes. Here, the examiner is practically baiting us into answering that the apprehension of Raul was a textbook case of how arrests for illegal possession of dangerous drugs or illegal possession of drug paraphernalia must be handled in the real world. We even have the participation of the evidence custodian. However, there is one critical step that was omitted in this case. Section 21 of Republic Act No. 9165 as amended by Republic Act No. 10640 provides that the apprehending team having initial custody and control of the dangerous drugs, controlled precursors, and essential chemicals, instruments or paraphernalia, and or laboratory equipment shall immediately after seizure and confiscation conduct a physical inventory of the seized items and photograph the same in the presence of the accused or the person or persons from whom such items were confiscated and or seized, or his representative or counsel with an elected public official and a representative of the National Prosecution Service or the media, who shall be required to sign the copies of the inventory and be given a copy thereof, provided that the physical inventory and photograph shall be conducted at the place where the search warrant is served, or at the nearest police station, or at the nearest office of the apprehending officer or team, whichever is practicable in case of warrantless seizures. Provided finally that non-compliance of these requirements under justifiable grounds, as long as the integrity and the evidentiary value of the seized items are properly preserved by the apprehending officer or team, shall not render void and invalid such seizures and custody over said items. Here, Police Officer Pepe failed to have his inventory signed by Raul, by the barangay kagawad, by the representative from the Department of Justice, and by the media practitioner. It also appears that no copies were ever given to them. In People v. Lim, the Supreme Court has ruled that the failure of the apprehending team to strictly comply with the procedure laid down in Section 21 of Republic Act No. 9165 will not automatically render the seizure and custody over the items as void and invalid. For the exception to apply, the following conditions must be present in order to justify a minor procedural lapse. Number 1, there must be a justifiable ground for non-compliance. 2, the integrity and evidentiary value of the seized items must be properly preserved. In this problem, these two conditions are not present. As a police officer of 15 years in the service, Pepe has no excuse for failing to secure the signatures of the required witnesses to his inventory. So, we begin our suggested answer with, no, if I were the judge, I would acquit Raul because of the violation of the chain of custody rule. Notice kapatid that we began our suggested answer with in this problem. Masakit sa mata ang mabasa ang in the case at bar dahil wala naman tayo sa korte at ito ay isang academic exercise. Hindi mo yun ikinakatalino kapatid. Pwedeng-pwede na rin kami sa Here, dahil madali lang itong dot-dotin sa iyong keyboard. I hope I'm still making sense. Next, we need to write our legal basis. The law does not require that you cite the entire provision of the law. All that matters is you write the most relevant portions of the law. The chain of custody rule requires that a physical inventory of the seized items must be made in the presence of the person from whom the items were seized, or his or her representative or counsel, and a representative of the media, a representative from DOJ, and an elected official. In all cases, these witnesses must sign all the copies of the inventories and be given a copy thereof. Notice, kapatid, that I have used the precise language of the law. The law demands precision in everything we do. However, I have taken the liberty of not writing the entirety of the provision. Doon lang tayo sa relevant, mahalaga, at magagamit natin sa susunod na paragraph. Our next line is our most important paragraph, our arguments. This is where you have to argue. Ilaban mo yan, kapatid. You cannot parrot back to the examiner the facts that he or she has written down. Wala siyang paki dito, kapatid, dahil siya ang nagsulat ng problem. Malamang sa malamang ay alam din naman niya ang kwento nito. In this next line, we have to tell the examiner why we have taken this position and why we have chosen this legal basis. We have to give back to the examiner what he or she needs. It's our chance to say, "Ha, I see what you did there." We do this by arguing why we are correct. In effect, we need to sell to the examiner why we are correct. You can land at the correct answer, kapatid, pero kung hindi mo naman ito maibebenta, kung hindi mo naman makukumbinsi ang examiner na tama ka, ay wala ka na rin pinagkaiba sa ilang libong sagot na dadaan lang sa kanyang mga mata. We stand out by first being hyper-responsive to the problem, and second, through our eloquence. This begins by laying down the strongest argument. What is our strongest argument here? The strongest argument here is that Police Officer Pepe failed to comply with the requirements laid down in Section 21 of Republic Act No. 9165. He had all of the necessary witnesses but failed to have them sign the inventory. Sayang, no? Now, how do we say all of this in the simplest, most concise manner possible? In this problem, Raul should be acquitted because the barangay kagawad, the representative from DOJ, and the media practitioner did not sign the inventory. There is no justifiable ground for the non-compliance of this rule. Notice, kapatid, that we began our suggested answer with "in this problem." Masakit sa mata ang mabasa ang in the case at bar dahil wala naman tayo sa korte at ito ay isang academic exercise. Hindi mo yun ikinakatalino, kapatid. Pwedeng-pwede na rin kami sa here, dahil madali lang itong dot-dotin sa iyong keyboard. I hope I'm still making sense so far. Next, you need to phrase your answer in the form of an argument. You are in law school because you are hoping that someday, one day, you will be a lawyer. At a certain point in your life, kapatid, you will be arguing for a living. Hindi ko naman sinasabi na maging palaaway ka, kapatid. Arguing means convincing your professor, your examiner, or the courts on the merits of your position. Arguing means selling your position and convincing your professor of the correctness of your answer. In your third paragraph, you need to argue. Hindi ka pwedeng umulit lang ng facts. Wala ka nang magiging kaibahan sa ilang libong booklet o answer sheet na dadaan lang sa mata ng mga examiner. Dapat kapag binasa ng professor mo ang sagot mo, masasabi niya na magiging abogada ang batang are. With our conclusion, the suggested answer should look like this. No, if I were the judge, I would acquit Raul because of the violation of the chain of custody rule. The chain of custody rule requires that a physical inventory of the seized items must be made in the presence of the person from whom the items were seized, or his or her representative or counsel, and a representative of the media, a representative from DOJ, and an elected official. In all cases, these witnesses must sign all of the copies of the inventories and be given a copy thereof. In this problem, Raul should be acquitted because the barangay kagawad, the representative from DOJ, and the media practitioner did not sign the inventory. There is no justifiable ground for the non-compliance of this rule. For this reason, Raul cannot be convicted of illegal possession of drug paraphernalia. The worst mistake you can make in a conclusion is to simply repeat your opening statement. This would be a waste of your examiners or professors' precious time and attention. Marami ring hindi na lang nagsusulat ng conclusion dahil ayaw na lang nilang umulit lang ng first sentence. When you don't know what to write, focus on the fruits, effects, and results. Assuming that your answer is correct. Ano kaya ngayon? Salamat kapatid at sinamahan mo ako sa ilang minuto na tayo ay nagsagot ng isang bar exam problem. I will be doing my best to respond to all of your answers in the comments and give you timely feedback. Sana at kahit papano ay may natutunan ka. The means and methods I've discussed here are all contained in our digital workbook 8, 101 practice problems for lost law students and bar takers. Here you will be tasked with answering about 105 bar problems spread out in various bar subjects. All of the answers here are broken down, explained, and discussed in much greater detail than what we have done here. You will also learn about how examiners draft their problems, where questions come from, and how to predict with a reasonable degree of accuracy the problems that might come out in your midterm and final exams. In this workbook, I've also discussed the common tactics that professors use to confuse law students and baristas. At ano ang pwedeng pangontra sa mga tactics nila? Narito rin ang mga typical na mali ng mga law students sa kanilang mga sagot at kung paano natin ito gagamutin. Follow along the journey as we help you take your answers from miserable to elegante. Grab your copy of 8, 101 practice problems for lost law students and bar takers through the links in the description box below. If you would like to see more episodes on how to answer law school exams and bar problems, please let me know by typing yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.